IRS Commissioner John Koskinen was on Capitol Hill today for a House Judiciary Committee hearing on alleged misconduct at the tax collecting agency. This was the third in a series of hearings on Koskinen's response to congressional subpoenas for emails from the agency. This is about 3.5 hours.
Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare a recess of the committee at any time. We welcome everyone to this morning's hearing on the impeachment articles referred on John Koskinen, Part 3, and I'll begin by recognizing myself for an opening statement. The Constitution sets forth a system of checks and balances which grants each branch of government tools to help ensure that no one branch of government attains too much power. The legislative branch's tools include the power to write the laws, the power of the purse, the impeachment power, the power to censure, among others. These tools empower Congress to exert oversight over the executive and judicial branches, including rooting out corruption, fraud, and abuse by government officials and taking further disciplinary action on behalf of the American people when warranted. The duty to serve as a check on the other branches, including against corruption and abuse, is a solemn one, and Congress does not and must not take this responsibility lightly. That is why this committee has scheduled this hearing today. In 2013, the American people first learned that their own government had been singling out conservative groups for heightened review by the IRS as they applied for tax-exempt status. This IRS targeting scandal was nothing short of shocking. It was a political plan to silence the voices of groups representing millions of Americans. Conservative groups across the nation were impacted by this targeting, resulting in lengthy paperwork requirements, overly burdensome information requests, and long, unwanted delays in their applications. In the wake of this scandal, then IRS official Lois Lerner stepped down from her position, but questions remain about the scope of the abuses by the IRS. The allegations of misconduct against Mr. Koskinen are serious and include the following. On his watch, volumes of information crucial to the investigation into the IRS targeting scandal were destroyed. Before the tapes were destroyed, congressional demands, including subpoenas for information about the IRS targeting scandal, went unanswered and were not complied with. Mr. Koskinen provided misleading testimony before the House Oversight and Government Reform Committee concerning IRS efforts to provide information to Congress. These are very serious allegations of misconduct, and this committee has taken these allegations seriously. Over the past several months, this committee has meticulously pored through thousands of pages of information produced by the investigation into this matter. On May 24, this committee held a hearing at which the House Oversight and Government Reform Committee formally presented its findings and evidence to the members of this committee. Then, on June 22, this committee held a second hearing to allow outside experts to assess and comment on the evidence presented to the committee at its May 24, 2016 hearing, and the options for a congressional response. Today, we hold a third hearing and hear from Mr. Koskinen himself. I look forward to hearing from Mr. Koskinen today. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members, and I want to thank first Commissioner Koskinen for joining us today on short notice and under these unusual circumstances. Last week, a handful of my colleagues attempted to force a vote on your impeachment, and when it appeared that they would fall short of the necessary votes, that effort was abandoned, and this hearing was scheduled instead. I hope that my colleagues now see what I see when I look back at the history of impeachment in the House of Representatives, which we all have an obligation to do. No matter how we feel about a particular official, no matter what we think of his or her agency, successful impeachments are bipartisan efforts, and partisan attacks cloaked in the impeachment process are doomed from the start. Mr. Chairman, the effort to impeach Commissioner Koskinen is destined to fail on both the merits and as a matter of process. And if they somehow force this measure to the floor again, I fear it will set a terrible precedent. On the merits, the Commissioner's critics simply have not proved their case. In fact, every other investigation to have examined these facts have refuted the charges against Commissioner Koskinen. The Senate Finance Committee, in a report that serves as the only bipartisan account of the matter, found no evidence that the Commissioner had intent to mislead Congress at any time. The Department of Justice found, and I quote, found no evidence that any IRS official acted based on political, discriminatory, corrupt, or other inappropriate motives, end quotation. And, quote again, no evidence that any official attempted to obstruct justice, end quotation. The Treasury Inspector General for Tax Administration again found no evidence to show that IRS employees had been directed to destroy or hide information from Congress. Despite these findings, some members continue to insist that the Commissioner ordered, quote, ordered 24,000 emails erased before Congress could review them, in quotation marks. Citing zero evidence to back the claim, independent fact checkers rated this statement as categorically false. There's simply no evidence that the Commissioner has acted with intentional bad faith in his leadership of the Internal Revenue Service. But even if there were some evidence of wrongdoing, the push to impeach the Commissioner on the House floor without even basic due process in the committee is wildly misguided. According to parliamentarians of the House, past and present, the impeachment process does not begin until the House actually votes to authorize this committee to investigate the charges. In other words, this is not an impeachment hearing. Merely including the word impeachment in the title doesn't do the job at all. And at an actual impeachment hearing, the Commissioner would be represented by counsel, and he'd have the right to present evidence, the right to question the evidence presented against him. In this case, by contrast, the Commissioner has been denied access to the transcripts of interviews conducted by the House Oversight Committee, even though we are told that those transcripts were key in forming the charges against him. Many members of this committee are in the same position, I might add. I'm not alone in being skeptical of short process or in noting the importance of a full and independent investigation by this committee. In 2006, Mr. Sensenbrenner, the gentleman from Wisconsin, argued, and I quote, "Only after the House Judiciary Committee has conducted a fair, thorough, and detailed investigation will committee members be able to consider whether articles of impeachment might be warranted," end quotation. In 2010, Mr. Chairman, you expressed confidence in our impeachment task force because it had conducted an exhaustive investigation. That investigation included, in your words, quote, "reviewing the records of past proceedings, rooting out new evidence that was never considered in previous investigations, conducting numerous interviews and depositions with first-hand witnesses, and conducting hearings to take the testimony of first-hand witnesses and scholars, in quotation marks. All of that process is missing here. Yes, we have it within our power to skip these steps, but what kind of precedence does that set? Never in the history of this body have we impeached a government official without first proving that he has acted in deliberate bad faith. Never in modern practice have we declined to provide the accused with the most basic due process, the right to counsel, the right to present evidence, and the right to question the evidence against him. If the Commissioner's critics have their way, I fear we will have a new rule going forward. The House may impeach any government official for any reason, without supplying evidence of deliberate wrongdoing, without an independent investigation, and without regard to basic fairness towards the accused. Forcing a vote in this manner will certainly not result in the removal of the Commissioner. Even if his critics succeed here, senators of both parties have already stated their intent to bury the matter. And in the process, I fear, we will have stripped our responsibilities of their weight and dignity and turned impeachment from a constitutional check of last resort into a tool of political convenience. And I cannot accept that, and none of us should. Commissioner Koskinen, thank you again for your willingness to be here today. Stick to the law and the facts, and you'll be fine. I yield back, Mr. Chairman, and I thank you.
Chair thanks the gentleman. Without objection, all other members' opening statements will be made a part of the record.
And before you answer, let me just follow up. Again, strictly hypothetical. Let's say there were a $10,000 portrait of the individual, and he used the foundation's money to buy it, put it in one of his for-profit businesses, writing a check out of the charity auction drawn on the charity using other people's charitable tax-free donation, but using the portrait in his for-profit business. So I get a bunch of money, I put it in my foundation, we don't pay taxes on it, I go and bid on a portrait of me, and then I put it in my business. Would that, in your opinion, be legal within the law and consistent with someone who declares himself a law and order individual?
Congressman, I said at the start I came here to answer questions truthfully and straightforward, but I can't, we don't talk about individual cases, and if hypotheticals begin to look like individual cases, I'm not at liberty to give opinion or judgments about those.
But Commissioner, you do know whether something's legal or not. I mean, here's the question. Can someone take money from a non-for-profit foundation and pay off a legal settlement, court settlement, to pay that debt off?
What I can say is...
Can you use tax-exempt money to pay for business purposes?
As I said before, the law is clear. Any tax-exempt organization cannot use its money to benefit anyone closely associated with that organization. But I can't give you... Every case is different. Every case has background and information surrounding it.
Commissioner, you know who I'm talking about. Everybody in this room knows who I'm talking about. Right? So all we want is a straight answer, right? I know, can he get a haircut?
The time of the gentleman has expired.
Buy new suits? What can he use with that tax-exempt charitable money?
The time of the gentleman has expired. The Commissioner will be allowed to answer the question if he chooses.
As I would stress, I think it's important for all the taxpayers to understand. If you deal with us, your information we go to great lengths to protect. Our employees understand every taxpayer's information is sacrosanct. We do not reveal it to anybody. And it's important for them to understand that we do not discuss anything about their tax situation with the public. And so while I understand the interest in this issue, even in a hypothetical sense, it would be inappropriate for the Commissioner or anybody else at the IRS to respond other than to say the law is clear as to what 501c3s can do and cannot do.
The chair recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Commissioner, I want you and I to do something that those of us who serve in government probably ought to do with a little more regularity, which is put ourselves in the shoes of the people that we purport to work for. I want you to imagine waking up and you learn that agents of an agency that you already fear, one of the most feared agencies in all of government, with a lot of control and power, either real or perceived, over your life. Some agents of that agency are targeting people based on their political ideology. And those are folks in positions of leadership. I don't know if you've read Lois Lerner's emails or not, but there is a palpable animus, a hostility towards conservatives that comes through in her work emails. These are work emails. This is not her musing about an op-ed in the Washington Post. These are work emails demonstrating a tremendous enmity towards conservatives. And some of those groups wanted to do nothing more than just educate their fellow citizens about the Constitution. And so I'm sure you can appreciate the irony of Lois Lerner punishing people who want to educate their fellow citizens about the Constitution, and then she comes and hides behind it to avoid answering questions about her conduct. That's why people are upset. And then you add to that the President of the United States, the person who campaigned as the great uniter, that the same rule should apply to everyone, really didn't mean it after all. And he prejudges an investigation while the investigation is pending. So against this backdrop, Congress, I'm sure you will agree, has not only the right, but frankly an obligation to provide oversight over an agency where that is the prima facie evidence at bar. We have an obligation to do it. But the efficacy of our investigations depends upon the fullness of the information we're provided and the honesty of the witnesses that come before us. We are of no use if we have incomplete information or those that we seek information from are not truthful. So there's a piece of your testimony that has troubled me, and I want us to go through it. And this is what you said. Since the start of this investigation, every email has been preserved. Nothing has been lost. Nothing has been destroyed. So I want us to go through it. What did you mean by since the start of this investigation?
I meant since the response, as you note, the appropriate congressional response to the IG report in May of 2013 when the 6 investigations started. The investigations there, as I said, were 4 congressional, the IG and DOJ.
All right, so you and I are in agreement. You meant from the very inception of the investigation.
Correct.
And then your next, this is under oath. I think you'll agree it's material, it's important. We're not asking you about something unrelated to the investigation. It's under oath. The next thing you say is every email has been preserved. What did you mean by every email?
I meant by every email that the IRS had that I knew of had been preserved. That's what I thought. That was my honest belief. Well, then why didn't you say that? Pardon?
Why didn't you say that?
Well, if I knew then what I know now, I would have testified differently. But at the time, I testified honestly on what I knew and what I had been told.
Well, then
and
that gets us...
Nobody regrets more than I do that in some ways this case has been the case that keeps on giving with new information coming out. I wish the information had all been out to begin with.
Well, Commissioner, it is always an option to say, I don't know. Loretta Lynch has made a living answering questions with, I don't know. It is always an option to say, based on what I was told. But you were incredibly definitive. You said, every email has been preserved. May not have been paying attention. You said nothing has been lost. What did you mean by nothing?
What I meant at that time was I had been advised nothing. But you're exactly right. In retrospect, I would have been better advised to say to the best of my knowledge or on the basis of what I've been told, which was, in fact, the basis of my testimony.
Well, I'm out of time, but this is what I would like you to do, because this is an important matter. I was one of the folks who wanted this hearing. I think this is really important. And you should be able to provide us information, but Congress should have all of that information.
Exactly.
So what I would like for you to do for me is you use the word mistake. That is the lowest level of scienter. There's mistake, there's reckless disregard for the truth, there's a deliberate indifference, and then there's intent. I'd be curious what you think the proper punishment is for each level of that scienter. And the other thing I need you to do is, to the extent you relied upon other people's counsel or what they told you, I need to know who they were. This committee, and I would think you would want us to interview every single witness that has access to information that would be relevant.
I think you have interviewed all of them already.
So you cannot think of a single person that this committee should interview that we have not already interviewed.
As to my knowledge, at this time, you have interviewed the first 50. I don't know the names of all the 50, but the people who advised me throughout this case, you have interviewed.
Would you do me the courtesy of making sure with your lawyer that the record is complete? Because whenever the record is complete, that's when we have to make the decision. And I am giving you the opportunity, under the heading of due process, to make sure that every bit of information you think should be considered is in fact in the hands of this committee.
Well, I would just note, and without going into detail about it, there's a lot of information and misinformation and misinterpretation of it that's in the hands of the committee. And if there were going to be a full hearing, I would have the opportunity to explore that. We would be able to cross-examine witnesses. We would be able to actually provide you not just the allegations being made, but the facts on both sides. Each side would have the opportunity, but the impact of the facts. You should hear from the Inspector General directly. Who did he talk to? Is he still, as he said in his letter, confident that it was an honest mistake by two employees? It was not purposeful. You should.
That's what I'm asking.
Yeah.
Give me a witness list, because you can't cross-examine them until we have examined them.
That's correct. I'd be happy to provide you the witnesses and the information that this committee would need to be able to actually proceed accordingly. But as noted, that would be if the committee decided it wanted to go to a full-scale impeachment process, which I understand this is not.
Thank you, Mr. Chairman.
Time of the gentleman has expired. I allowed additional time because that's a good exchange of what needs to happen. The chair recognizes the gentleman from California, Ms. Bass, for 5 minutes.
Thank you, Mr. Chair. Mr. Commissioner, let me begin by joining in with my colleague on the other side of the aisle and thanking you and your staff for being of great assistance to my constituents in Los Angeles. I've had several members of the community that have had some difficult situations, and your staff has been very responsive.
Thank you.
I know when you took over the IRS, one of the reasons why you were asked to fulfill this assignment is because of your history of addressing organizations that were having big challenges. And I wanted to know if you could describe what specific challenges the IRS faced at the time you took over the organization.
When I took over the organization, first we needed to make sure that the situation that led to the improper selection of people just by their names never happened again. And so we've pursued, and as people have made recommendations over which we have control, we've adopted those. We had a substantial challenge when I started with the underfunding of the agency, which still continues, in terms of implementing not only the normal tax seasons, but we had the Foreign Account Tax Compliance Act, we had the Affordable Care Act, since then we've had the ABLE Act, we've had the Health Coverage Tax Credit Act, we've had private debt collection requirements, all of which have been basically unfunded mandates that the IRS has had to implement. We are under constant attack by organized criminals around the world trying to get access to our information. So our cybersecurity issues and our antiquated IT systems are a major concern and a major attack for us.
So, go ahead.
And the last thing is we provide tax credits pursuant to statute, particularly with the Earned Income Tax Credit. And I've been concerned from the start that we need to do everything we can to get the level of improper payments down, make sure everybody eligible participates, but make sure that the right amounts go out. And it's been a very complicated challenge.
So with all of those challenges, it's my understanding that the IRS has spent about $20 million and devoted over 160,000 hours to collect, review, and produce over 1.3 million pages of documents to Congress. With all of that effort, all of that time, and all of those pages, were these primarily related to the 501c3-4 issue?
These were all related to the 6 investigations.
So how, and are those numbers accurate?
Pardon?
Or are those numbers accurate in terms of the amount of money,
Yes, those are the numbers.
time,
Basically,
and
it's
pages?
$20 million. We've had 250 people at various times working either full-time or part-time, doing our best to respond as quickly as we could to congressional requests.
So how did all of that time and money assist the IRS in addressing the number of challenges that you laid out?
The best it was going to do, and I hoped it would do in some ways better than it has, would be to try to assure people that we understood the nature of the problem, which the IG had reported on 6 months before I started, and then we would have a basis for trying to solve that problem. And I think we've done, taken all the recommendations anybody's had, because I think it's critical, going back to the issue about confidence in the IRS and in the government, for people, as I said, to believe that they're going to get treated fairly. We don't care whether they belong to one party or another, whether they go to church, they don't go to church, who they voted for, what their political beliefs are. They should be treated the same way as anyone else, and all of that background is not relevant to us at all.
You know, when the whole controversy was taking place, I found it interesting, the concern over conservative organizations, because I'm very familiar with a number of liberal organizations that felt they received extra scrutiny beyond what was appropriate by the IRS. One of the root problems here in general is the time it takes for the agency to process applications for tax-exempt status. And I know in recent years, especially after Citizens United, the agency was overwhelmed by applications for C3 and C4 status. I wanted to know how you've addressed this problem, and is there currently a backlog?
Presently, there is no backlog. For a C4 application, it now takes an average of 83 days to go through. For C3s, where we had a backlog of 65,000 applications when I started, we've streamlined the process for small charity applications and allowed them to get through in a matter of weeks rather than 9 to 12 months. And there is no backlog. Our goal is for the complicated C3s to get them out within 270 days, and we meet that. For C4s, most of them get handled very quickly and under expedited processing, so there are no backlogs.
And are you still getting a flood of applications, and can you give an example of how things were streamlined?
At this point, we have about 1.5 million subchapter S, C organization, tax-exempt organizations. 75% of them are C3, only about 5% are C4s, and the majority of the C4s are garden clubs, Kiwanis clubs, local groups. But every year we get a couple thousand C4 applications, and as I say, the average time for processing now is 83 days.
Thank you. My time is up.
Chair thanks the gentlewoman and recognizes the gentleman from Utah, Mr. Chaffetz, for 5 minutes.
Thank you, Mr. Chairman. Mr. Koskinen, in your opening statement, you said that you had instructed people in writing to preserve their records. Could you please provide this committee and the Oversight and Government Reform Committee a copy of those emails?
Copy of the email. Sure, we'd be delighted. I think my statement said that we instructed those. I did not personally send an email.
You didn't? Okay, we'll go back and look at the record. If there are any emails asking people to preserve those documents, we'd like to see those because we don't think we have them. We'd
be happy to provide those.
Do you stand by all of your previous congressional testimony?
I've noted that if I knew then what I know now, I would have testified in a different way.
What in your previous congressional testimony needs to be clarified or altered or updated?
Well, I tried to make that clear. Clearly, at the time I testified, I was advised that, in fact, all the evidence was being preserved pursuant to the orders that went out. Since then, it's been clear that obviously some tapes were erased, which was a mistake. I said that at the time. If I were testifying again, I would say...
Part of the problem that we have is that you've never clarified your testimony. This is the first time we've ever heard you say mistake. This is the first time that you said that you've provided essentially false testimony. That's the way I read it. When you said on June 20th of 2014, quote, since the start of this investigation, every email has been preserved, nothing has been lost, nothing has been destroyed, end quote. Was that a mistake? or was it false?
That was an honest statement on the basis of what I knew. As Congressman Gowdy said, I would have been better advised if I had said on the basis of what I've been told and I understand.
But you told us in a hearing on July 23rd, you told Mr. Jordan that you learned in April that these emails were missing.
You have to understand there are two sets of emails. The emails that I knew were missing in April of 2014 were from the Lois Lerner hard drive crash. No one knew until 2015 about the erasure of the tapes in Martinsburg. When I testified in June, our whole focus, because none of us, the committee nor I, knew about the
Why
erasures.
are you testifying that since the start of the investigation, nothing has been lost, nothing has been destroyed?
At the time I testified, that hearing was about the Lois Lerner hard drive crash, so it was clear Lois Lerner's hard drive had
But you
crashed.
also testified a couple weeks later that you knew in April there was a problem. In fact, Kate Duvall, your senior person, knew in February, but you said you personally knew in April, and yet you came before Congress and you gave these definitive statements.
Well, if you look at the timing of it, you had the report from us on the entire production system and the Lois Lerner hard drive
But what
crash
you said was
before I
false.
testified.
Was it true or false what you said?
It was true as far as I knew, and when I testified...
But in April, you said you knew in April that there were missing emails.
Yes, and I filed a report with the Congress.
How can you simultaneously say that you know there are missing emails in April, and in June you say, since the start of this investigation, every email has been preserved?
Because Lois Lerner's emails were lost in 2011, long before the investigation started, and that hearing was about the Lois Lerner hard drive crash.
Let me ask you another quote. True or false? We confirmed that the backup tapes from 2011 no longer existed because they had been recycled pursuant to the IRS normal policy. On July 23rd, you said, quote, confirmed means that somebody went back and looked and made sure that, in fact, any backup tapes that had been existed had been recycled. Is that true or false?
That was true in my belief at the time. Congressman Gowdy.
Who went back and looked?
I was told that the IT department
Told
had...
by who?
I was told by people, and you have interviewed
Who are these
all of
people?
those people. Who are those people?
Yes.
It was the Deputy Chief Information Officer, whom you've interviewed, who said to me that they had looked and they were confident that, in fact, I asked, is there any way to get tapes? He said they've all been recycled.
But nobody went back and looked. In fact, Mr. Camus, who's the head of, who was the deputy there at the Treasury Inspector General, said the best we can determine through this investigation, they simply didn't look for those emails. So for the over 1,000 emails that we found on the backup tapes, we found them because we looked for them, end quote. How is it that you spend $20 million, 250 full-time people, and you never looked for them, according to the Inspector General? And you testify that you went back, in fact, and confirmed. That is false.
That's what I was told at the time. That was my understanding at the time. As I've said, if I knew then what I know now...
And when did you inform Congress that this is your view now? When did you tell Congress that you were wrong on this?
When the IG reported in 2015, I subsequently had a hearing with the Senate Finance Committee about this, and I testified. In fact, I publicly stated in response to the public issues that it was a mistake for those tapes to be erased, and I testified with the Finance Committee.
You know it was a mistake, but they were erased after a duly issued subpoena. That's where we have a fundamental problem. You issue 66,000 summons and email and subpoenas each year. You know how to dish it out, but you don't know how to take it. And so we issue a subpoena, we expect you to comply with it. And when you destroy documents that are under subpoena, somebody's got to be held accountable for that. And that starts with you. You provided false testimony to this committee, you've provided false testimony to the Oversight and Government Reform Committee, and you should be held accountable for that. I got about 30 minutes more questions, Mr. Chairman, but I will yield back.
Chair, thanks, gentlemen, and recognize the gentleman from Louisiana, Mr. Richmond, for 5 minutes.
Mr. Chairman, I'll just pick off where my good friend from Utah left off, and that's conversation about being held accountable. You don't know me, but I did criminal defense for a while, and I was a state rep. And in Louisiana, I watched many people get indicted and go to jail for the misuse of nonprofit funds.
And in your testimony, you say that one of the important things with the IRS is for people to feel that they will be treated fairly and that it doesn't make any difference who they are, what organizations, or what political party they belong to. Well, let me just tell you, there are a bunch of people, including me, that think that the justice system is rigged for those who are privileged and those who are rich. So for the people that I have seen go to jail for misappropriating $2,000, $3,000, $5,000, $8,000, and we have an indictment that's pending right now. The question becomes, how can someone take money that belongs to a nonprofit to satisfy a personal judgment and that not be a misappropriation of the nonprofit's funds?
I don't know the details. All I can say, as I've said, the law is clear. A C organization cannot use its assets to benefit anyone who is closely associated with the organization.
And to pay off a personal judgment would be a benefit to a person, not an organization.
Whatever you use to not pursue charitable purposes, but to benefit anyone associated with it, the law says you should not is not allowed.
Let me just say this, and I wasn't even going to bring that up because I think today is a very unfortunate day, but it signals what this Congress has been about and why our approval rating is so low and why our reputation is the do-nothing Congress. We do something. We grandstand and showboat on a regular basis. This Judiciary Committee in this room weeks ago, after Philando Castile and Alton Sterling were killed by law enforcement, I begged for a public hearing on the issue because I really think that the public deserves it, and I think if we don't do it, we're going to have blood on our hands. Well, unfortunately, police officers were killed. This week, we have 2 more incidents where 2 people were killed in an incident with law enforcement, or 2 people lost their lives in an incident with law enforcement. But we're not talking about it. We're talking about a fragile country. We're talking about fragile people, and we are ignoring a humongous issue because we're talking about impeaching you. In Louisiana, we just had 7 trillion gallons of water dumped on Baton Rouge and the surrounding areas. Just in Baton Rouge, we lost 60 sheriff deputy cars. We lost 50 police cars. We have a law enforcement that is dismantled. But we're not having a hearing here today to talk about how we help them get back up because there's a pending Alton Sterling decision that has to come out. And how do we protect American citizens and how do we keep that community safe when that decision comes out, because we know it's coming? But we're, again, talking about impeaching you with 50-something, I don't know, 100 days left in our term. We keep grandstanding while America is burning. There's some who would rather talk about Colin Kaepernick not standing for the national anthem than to talk about people losing their lives by the hands of law enforcement. This is the Judiciary Committee. We don't even acknowledge, we're not even talking about the fact that we are losing law enforcement officers. We don't even have enough bulletproof vests for the sheriffs in the United States of America, but we're talking about impeaching you. We just had police officers and sheriffs gunned down in Dallas and in Baton Rouge, but they don't have police vests, and we're talking about impeaching you. Somewhere, somehow, you have to say, what are these guys thinking? What are these guys and women doing? Do they not realize that we have a crisis in America and we're talking about impeaching you? Which, you know, is laughable at its best if it wasn't so sad that all of a sudden this becomes the biggest priority that we have. And Mr. Chairman, I would just again urge, and I want to be on the record every time we talk, that we need a public hearing so that people understand how serious we are taking the policing in America issue. Because again, if people don't understand we're taking it serious, they will continue to take it in their own hands. People that are mentally disturbed will do unimaginable things, and it's all on us if we don't get together and talk about it. With that, I will yield back.
Chair thanks the gentleman. Recognize the gentleman from Texas, Mr. Gomert, for 5 minutes.
Thank you,
for
Mr.
purpose, the gentleman from Utah, secret.
I just asked unanimous consent to enter into the record the GAO report from July 2015. Internal controls for exempt organization selection should be strengthened. Critical that, as Mr. Jordan talked about, that the IRS has not fixed the targeting problem.
Without objection, it will be made a part of the record. And now Mr. Gomert is recognized.
Appreciate my friend from Louisiana pointing out the grandstanding. That's kind of what I felt about the sit-in that occurred on the House floor, and my friends across the aisle refusing to recognize that radical Islam is at war with us. And instead, they talked about guns. I'm looking forward to the grandstanding about pressure cookers and the need to make them illegal. But this hearing is about whether or not Mr. Koskinen, you committed such acts as should cause you to be removed from office. And it's already been mentioned that you had testified, that you were made aware of problems associated with Ms. Lerner's emails the same month that Ms. Duvall discovered the gap, and that you had withheld that information, didn't disclose it for 4 months until June 13th of 2014. And that during that time you testified before Congress 4 times. So I want to ask you, during those 4 times you testified, after you learned about the problems with Ms. Lerner's emails, did it cross your mind at all that perhaps you should disclose that there were problems with Ms. Lerner's emails?
If I could correct the record, I have testified, and honestly, I learned about the Lois Lerner email crash in April. Between April and the time we provided the report to the Congress, I did not have a hearing. The hearings in June were about the Lois Lerner hard drive crash. But I've also stated, and the reason I did not immediately report that crash was because I instructed people to see how many emails from the crash period we could recover. And we recovered 24,000. But as I've said in retrospect, because it did create a certain amount of aggravation on the part that I understand of at least some congressmen, in April, when I was advised, if I had to do it again, I would advise the Congress that we had a hard drive crash and we
So
were
is
now
it your opinion that once you've testified before Congress, if you learn information that makes your prior statements not completely true, that you have no obligation to come forward, send a letter, send an email, send a message that you have now learned things, or in your opinion, should you just wait until you're asked, and if you're not ever asked, you have no need to disclose? Which is your opinion?
I didn't wait until I was asked. We actually produced a full report to all of the investigators' committees about the process. But as I've said, when I learned of it in April, life would have been a lot easier if I had simply advised the Congress.
Well,
and since that time, we've advised the Congress.
When you found out there were problems, did you know Lois Lerner used a BlackBerry, that she had a handheld device?
I did not, but that BlackBerry was in the hand of the IG from 2013.
Did it cross your mind that she may have had a portable device that was used to send and receive email?
No, I was not analyzing Lois Lerner's activities. I was working and instructing people.
You knew there were requests for Lois Lerner's emails, and it never crossed your mind she might have them on a personal device that she carried? That never crossed your mind? Did it cross your mind that there was this facility in Martinsburg, West Virginia, where storage was kept? Did that cross your mind?
No, I was focused, as the agency was, on reviewing all the emails we could. To get emails, we had to pull each hard drive out of the computer.
Mr. Koskinen, when you are asked under oath about the existence of emails, there really is an obligation to learn about the emails and where they are and where they exist. Let me just read for you. I hope you're familiar with Internal Revenue Manual. You are, hopefully.
Yes.
Thank you. Well, this was added January 23rd, 2014, 25.1.1.2. Fraud is deception by misrepresentation of material facts or silence when good faith requires expression. And I would submit to you, Mr. Koskinen, you have had ample opportunities over the last 2 years to disclose things or maybe to make inquiry, but it certainly appears you have what might be called willful ignorance, so you don't have to come up here and testify about what actually happened. It's hard to believe that you never made any inquiry about potential places that Ms. Lerner's controversial emails that may have been lost, may have not have been lost, where they might be found. It shocks my conscience that the head of the IRS would not think to ask any questions other than, can anybody find her emails? You require so much more from taxpayers, and then we give you $290 million more dollars, and what happens? You start closing local tax assistance offices for taxpayers, like in Longview, Texas, and the excuse is, well, we got our budget cut. Yeah, this year you got $290 million more. 2 months later, you're closing offices to hurt taxpayers. It looks like there is a problem with the management at the IRS, and I see my time's expired, so I have to yield back.
The time of the gentleman has expired. The chair recognizes the gentleman from New York, Mr. Jeffries, for 5 minutes.
Mr. Commissioner, thank you for your presence and for your service. The chief sponsor of the impeachment resolution that resulted in this hearing is Republican Representative John Fleming from Louisiana. Is that correct?
It's my understanding he's one of the proposers.
And Congressman Fleming is currently a candidate for the United States Senate. Is that right?
My understanding. I'm learning from Congressman Gowdy.
Are you aware that Congressman Fleming is currently running television advertisements as part of this campaign that claims that the head of the IRS, that would be you, ordered 24,000 emails erased?
I am aware of that.
But the facts have already been established, I think, that the emails were inadvertently wiped by 2 low-level employees. Is that right?
That's correct.
And these employees worked the midnight shift. Is that correct?
Yes.
And they worked the midnight shift at a facility in the booming metropolis known as Martinsburg, West Virginia. Is that right?
That's correct.
Now, the Treasury Inspector General is a Republican, is that right?
Yes.
And he issued a report on June 30th, 2015, which concluded, quote, that no evidence was uncovered that any IRS employees had been directed to destroy or hide information. Is that correct?
That's correct.
The Republican-led Senate Finance Committee has uncovered no such evidence. True?
That's correct.
The Department of Justice conducted an independent investigation and also concluded that no IRS employee from top to bottom had been directed to destroy or hide information. Is that correct?
That's correct.
This is not a legitimate impeachment hearing. This is a political charade. It's a sham. It's a Hollywood-style production. The outcome has already been predetermined. The script has already been written. The witness has already been labeled a bad guy, because in any Hollywood-style production, there must be a villain, and who better than the commissioner of the IRS?
The foundation spent more than $250,000 to settle lawsuits that were filed against his business. Just a few remaining questions there. Is it illegal for the head of a nonprofit to use money from the charity to benefit himself or his business?
As a general matter, nonprofits are not allowed to. It's called inurement, use benefits of the tax-exempt organization for their own purposes.
Is it also illegal for a nonprofit group to make political gifts, such as the Trump Foundation's $25,000 contribution to the Florida Attorney General's reelection campaign?
I can't talk about any individual taxpayer's activities. The law is clear. 501c3 organizations cannot be involved in politics.
Right.
But I, again, would stress we never talk about any individual's tax returns or their policies.
Right. Commissioner Koskinen, we shouldn't have to ask you to talk about Donald Trump's tax returns. We should be free to talk about those tax returns because, as you've told us, there is simply no reason that he has not shared them with us. He's not been prohibited from sharing them with us. And, in fact, there's no rule that says that he can't at least provide the audit notice so that we can have some small piece of information that might help us. You're right. We can't learn everything there is to learn about his finances from his tax return, but it sure would be an important start for the American people, and I appreciate your being here to help clear some of that up, and I yield back the balance of my time.
The chair recognizes the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Mr. Koskinen, is the IRS still targeting conservative groups?
Absolutely not.
Mr. Koskinen, that's not what the United States Court of Appeals for the District of Columbia said. They just issued a decision on August 5th, 2016, last month. And I just want to read from that decision. They said, cessation has never occurred. The IRS has admitted to the Inspector General, to the District Court, and to this Court that applications for exemption by some plaintiffs have never to this day been processed. That sounds like still going on to me, Mr. Koskinen. Let me just read further.
Okay.
They say it's absurd to suggest that the effect of the IRS's unlawful conduct, which delayed the processing of plaintiffs' applications, has been eradicated when 2 of the plaintiffs' applications remain pending. Sounds like targeting still going on to me. Let me just paraphrase that. It's absurd to say targeting is stopped when the unlawful conduct continues. Again, this is not Jim Jordan saying this. This is not Donald Trump saying this. This is not the Freedom Caucus saying this. This is the United States Court of Appeals for the District of Columbia, decided just 6 weeks ago. So you guys are still up to it, aren't you?
Now, as I wrote in a letter to all of the oversight committees, including yours, there are 3 cases out of the 145 that have not been processed because they're in litigation, and our policy for years has been if you're in a process and then you sue us, we stop the process. But those are 3 from 4 or 5 years ago. They are not new cases. There is no new case in the last
these guys have been waiting 4 or 5, some cases 6 years. And you know, I figured you would say that, and so it doesn't carry much weight with me, and it frankly didn't carry any weight with the court. Because here's what the court said to that very argument. They said the IRS is telling applicants in these cases, quote, we've been violating your rights, not processing your applications. You are entitled to have your applications processed, but if you ask for that processing by way of a lawsuit, then you can't have it. So the court wasn't buying your argument. They don't care what your internal policy is. They're more concerned about people's fundamental liberties, and you guys continue to violate them. They go on to say this, we would advise the IRS, if you haven't ceased to violate the rights of the taxpayers, then there is no cessation. So if you're still doing it, if you haven't stopped doing it, then you're still doing it, is what the court said. You can't sit there and say you're not still targeting. So here's what we got to keep in mind.
Targeting is a present tense verb. Those organizations were improperly selected 4 years ago.
These organizations still don't have their tax-exempt status.
And as I noted, once the court made that issue, while we for 50 years have stopped processing, we are processing those applications.
Remember, Mr. Cotton, this is not me making the argument. This is not just all these, we've heard from the other side, these conservatives who want to impeach the IRS commissioner. This is the court saying you guys are still doing it. You're still, and never forget what happened here. Never forget the underlying offense. The IRS targeted people for exercising their most fundamental liberty, their right to speak against the policies of their government, and they got harassed for doing that. We've heard a lot about due process from the other side. I think you should get every bit of due process you're entitled to. But how about the due process that all these people were who got harassed for years, and 3 groups are still getting harassed today? Here's what happened. You guys, the IRS targeted folks, they got caught. Ms. Lerner, at first, she lies about it. She says, oh, it wasn't us, it was those folks in Cincinnati. Then she takes the 5th. That sort of puts a premium on all the documents and communications, making sure we get those. That's why we had 2 subpoenas and 3 preservation orders for that information. You come in to clean up the mess, and under your watch, documents are destroyed, false statements are made, 422 backup tapes are erased, and now the clincher, it's still going on. And so the other side can say we shouldn't be here today, you shouldn't have to sit through this. I'm saying, why haven't we done this a long time ago? You should have been going a long time ago when this is the record. Losing emails, Backup tapes destroyed. Targeting still continues to this day. Not Jim Jordan's words, not Freedom Caucus words, words from the Court of Appeals. For goodness sake, that's why this hearing is important, and that's why we should move forward with the articles that Mr. Chaffetz submitted 15 months ago and make sure that you no longer hold office. Mr. Chairman, I yield back.
Chair thanks the gentleman. Recognizes the gentlewoman from California, Ms. Chu, for 5 minutes.
Tapes had been erased. I said that was a mistake. It shouldn't have happened. And as has been noted, I run the organization, and if the honest mistake is made on my watch, it's my mistake. I tell employees that.
So you made several statements saying that those tapes should be preserved then? Your office
I did not make several. It had gone through the system. There was a standing order in 2013. There was a reminder that went out from my counsel to the IT department to preserve those reports. We were making a massive effort to production, so you would have thought everybody would have known that we're producing documents as fast as we could, and therefore we should protect them.
Thank you. I yield back.
Chair thanks the gentlewoman. Recognize the gentleman from Georgia, Mr. Collins, for 5 minutes.
Thank you, Mr. Chairman. Ms. Koskinen, thanks for being here. I think it's interesting that we have the Commissioner of the IRS here to give tax advice. I'm glad that you have worked with my office to actually help my constituents actually be able to get tax advice, where we had one person with 700,000+ people having to take golden tickets at a front door at 3:30 in the morning. I know we've added another one. I would like to see another added there, and we still have some ongoing correspondence that I would like some breakdown on the letters that I have shared with you.
And I'm delighted to do that.
And we'll continue. However, let me go back to just a couple, because you and I have had several conversations. This thing has round over several years, and we have had conversations when I was a member of Oversight Committee. And do you believe that, and just from your law, just to settle the same, a subpoena is a valid form of getting information from someone who is being asked for? It's like if the committee actually subpoenas the Treasury or the IRS to produce documents, that's a valid form of getting documents.
It certainly is.
And it is it should be followed, correct?
Yes.
Okay. In September 2014, I asked you, and this does not require a transcript, I'm going to give you your answer back, but it says, I asked if the IRS had produced all the emails from Holly Paz, as required by subpoena, this subpoena currently right here, at the Oversight Committee. I'd ask you the same question 56 days earlier, and the answer then was no, and then when I asked you the question in September of 2014, the answer again was no. My question to you today, have those documents been produced to the Oversight Committee?
I don't know. We've been working from the start with the committee staff to prioritize. We had a long hearing, as you'll recall, in March of 2014 about the order in which we would reply to the subpoena. I made it clear we were prepared to respond to the entire subpoena. That's how we ended up with the committee saying their first priority would be all of the remaining Lois Lerner emails, and I said we would provide those. Since then, we've been working with the committee and working our way through the subpoena in terms of whatever information they would want.
Okay. Well, and number two on this subpoena, just as the schedule, which was supposed to have been produced on August 16, 2013, a nice day, that was my birthday. It didn't get the gift of being produced, but on Holly Paz was number 2 on the list. Right. And on the actual required. My question is this: Holly Paz is not in a crash situation. Her hard drive was never in doubt. Why the delay here? Are you blaming the committee?
No. We've, as I say, the committee has a vast subpoena they're asking for, some information from 90,000 IRS employees. And at that hearing in March of 2014, we agreed that we would get Lois Lerner emails, and then we would respond to the committee staff as we went forward. We have provided Holly Paz emails. I just can't tell you whether all of the ones from Holly Paz that have anything to do with this issue have been provided. The question is, have we provided other emails that she may have sent? And I don't know the answer to that.
In your legal, in just your opinion as Commissioner, do you think that you're in compliance with this subpoena?
I think we are in compliance with that subpoena in terms of our discussions with the staff. We have not completed, as I say, one of those questions is emails from 90,000 employees outside, and I've explained in 2014 that would take a long time, and in our discussions with the committee staff, we are not pursuing that.
And we've understood that, but some of these were specifically named. The 4 people specifically named were not these vast amounts out here. Right. Holly Paz has no constructive problem with a computer. It was a hard drive. You could get it off of it. I know, and it sounds very frankly, and I know this, you're a very good witness in that you parse your words very well. That's a compliment, but it's also the very frustrating part of this whole thing. It sounds very much like you're blaming committee staff on their priorities here. I think at this point, this is the frustration that we all have with this.
I don't mean to do that, and I apologize if there's any indication that I'm trying to blame the staff. All I'm saying is we've been working with the staff in terms of response to the subpoena to the extent that, and as I say, we provided all of the Holly paths and all of everybody's emails regarding the determination. That's how the 1,300,000 pages came out. About, so I've forgotten how many hundreds of thousands of emails there are. To the extent that the committee at any time feels that there's additional information that we haven't provided, we've been providing information. We sent a note to everybody to say we're done with document production in January 2015. If we haven't provided all of the Holly Path's other emails that have nothing to do really with this, and the committee staff would like those, we will do that.
As I said before then, I'll say again now, this is what the American people just do not understand, the selective ability to, to work with a subpoena or not. And with that, Mr. Chairman, I yield back.
Right.
Chair thanks the gentleman and recognize the gentleman from Illinois, Mr. Gutierrez, for 5 minutes.
Sorry.
24,000 emails erased?
I am aware of that.
But the facts have already been established, I think, that the emails were inadvertently wiped by 2 low-level employees. Is that right?
That's correct.
And these employees worked the midnight shift. Is that correct?
Yes.
And they worked the midnight shift at a facility in the booming metropolis known as Martinsburg, West Virginia. Is that right?
That's correct.
Now, the Treasury Inspector General is a Republican. Is that right?
Yes.
And he issued a report on June 30th, 2015, which concluded, quote, that no evidence was uncovered that any IRS employees had been directed to destroy or hide information. Is that correct?
That's correct.
The Republican-led Senate Finance Committee has uncovered no such evidence. True?
That's correct.
The Department of Justice conducted an independent investigation and also concluded that no IRS employee from top to bottom had been directed to destroy or hide information. Is that correct?
That's correct.
This is not a legitimate impeachment hearing. This is a political charade. It's a sham. It's a Hollywood-style production. The outcome has already been predetermined. The script has already been written. The witness has already been labeled a bad guy, because in any Hollywood-style production, there must be a villain, and who better than the commissioner of the IRS? But here's the problem. The founding fathers of this nation gave to this House the power of impeachment as an extraordinary remedy, only to be used in serious circumstances. It is not a high crime or misdemeanor to be the head of an agency that some of my friends on the other side of the aisle don't like, as part of an administration that some of my friends on the other side of the aisle don't like. But it's been clear to me, as my good friend from Louisiana indicated, Rome is burning right now in the midst of a police violence crisis. But we're on this reckless legislative joyride to impeach the commissioner of the IRS. Why is that? Well, perhaps there's some in this town who have been determined to impeach a member of the Obama administration from the day that the President of the United States was sworn in January of 2009. But you couldn't impeach Barack Obama. You couldn't impeach Eric Holder. You couldn't impeach Hillary Clinton. And so some genius came up with the brilliant idea that we're going to go after the IRS commissioner. It's a dereliction of duty. It's the only reason why we're here today. And it's a waste of the time and the treasure of the American people. I yield back.
The chair recognizes the gentleman from Idaho, Mr. Labrador, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Koskinen, for being here. Your testimony suggests, and what was just indicated by my friend, suggests that impeachment is improper, and that you have attached many exhibits to that effect. You further stated that you are unaware of anyone on your level having been impeached in the past. In fact, you sent us a letter from a bunch of college professors, law professors, that says the reason for the salutary exercise of self-restraint by the House, meaning that we have never impeached anybody at your level, is that in our constitutional system, primary responsibility for supervising executive branch officials resides with the President, not with the Congress. But the question that we have to answer in this hearing is what happens when the President is not exercising that supervision over somebody like you. So maybe the question is not whether impeachment is proper, but maybe the question is why, after all of these disturbing instances of lack of candor, lack of transparency, and lack of fitness to serve, you still believe that you can competently serve as the commissioner of this agency. This country may not have a long history of impeachment at your level, but certainly we have a long, long history of officials at your level who have been subject to dismissal and resignation for similar or even lesser offenses than what you have perpetrated. Are you familiar with Michael Brown, the former director of FEMA?
I do not know him, but I know the position he held.
And do you know what happened to him following his mismanagement of the Katrina efforts?
I do not recall specifically. I know ultimately he left the government, but I don't know the
He resigned from office. Are you familiar with former DEA Administrator Michelle Leonhardt? Do you know what happened to her following the release of a watchdog report on agent misbehavior under her watch?
I do not.
She resigned from office. Are you aware of what Catherine Archuleta, the former OPM director, did following the 2015 OPM hacks by foreign governments?
That I do understand.
And what did she do?
She resigned.
She resigned. There are many examples of this, including the resignation of Secret Service Director Julia Pearson following security breaches, and ATF head Kenneth Melson over Fast and Furious. Well, I'm not going to spend my entire 5 minutes providing you with examples of agency heads at your level who have resigned based on agency failures. But however, I'm going to suggest to you why this is not a dereliction of duty. Your bosses refuse to actually hold you accountable for your actions. So there's only one branch that can do that, and that's our branch. Instead, I want to ask you, do you dispute that over 24,000 emails responsive to a congressional subpoena and investigation were destroyed during your tenure?
I do not.
Do you dispute that you testified before the Oversight and Government Reform Committee after that destruction that it was your intention to comply with the request for evidence and that you were planning on turning over all relevant email communication?
That testimony was not after anyone knew about that erasure.
But you testified that after that happened.
No.
Was
I did testify after it happened, just nobody knew it had happened.
Was anyone at the IRS, including the 2 low-level employees that you keep blaming for this, was anybody fired due to the destruction of evidence?
I would like the record clear. I don't blame them. At the time, I didn't blame them. The IG did a year investigation and found it was a mistake.
Was anybody fired for the destruction of evidence?
Those 2 people were not fired. The IG determined it was an honest mistake on their part.
So no substantive corrective action has been taken. So ultimately, sir, I will do what you ask us to do. I will judge you on your overall record. Your inability to successfully preserve the information requested and your so-called mistaken testimony clearly demonstrates that your overall record is one of gross incompetence and extreme negligence, and that your department exhibited such. Or worse yet, there was some intentional deception. We shouldn't need the articles of impeachment that we are talking about today, and we should need these hearings because you, Mr. Koskinen, should have resigned for your failures to properly carry out your duties and for failure to bring the transparency that you promised during your confirmation hearings. And with that, I yield back my time.
The time of the gentleman has expired. The witness will be permitted to respond if he chooses to.
Pardon?
You can respond.
No, I think if I have an overall record at the IRS I'm proud of. We've made significant progress across the board. I've talked about...
you have to respond to the specific...
But on the specific issue, I do not think that the mistakes, honest mistakes made by two employees are the grounds for either resignation or certainly not for impeachment. If, in fact, every time an employee makes an honest mistake in an agency, the expectation is that the head of that agency should resign, we're not going to have many agency heads around.
The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Commissioner, for being here today and for your service. There's clearly no evidence that the charges being leveled at you today have any validity whatsoever. In fact, multiple independent and bipartisan investigations have found that you in no way purposely misled Congress in any of your statements. The Treasury Inspector General, the Senate Finance Committee, and the Department of Justice have each conducted their own investigations on the so-called IRS targeting scandal. And while these investigations uncovered various management problems at the IRS, there was no evidence to support allegations of criminal activity or politically motivated behavior. There was no evidence to support allegations that you deliberately misled Congress or attempted to obstruct a congressional investigation. In fact, each of these investigations found no evidence whatsoever that you acted in bad faith. Under your direction, the IRS has spent $20 million and devoted more than 160,000 hours to collect, review, and produce 1.3 million pages of documents to investigating committees. The entire record, built on multiple investigations, fails to support the allegations leveled here today. And it's regrettable that rather than dealing with the issues of criminal justice reform, immigration reform, common sense proposals to reduce gun violence, that we are taking up time of this committee for this charade. So I want to ask you, since you are here, about the political contributions of charitable foundations. First, is it legal or illegal for a charitable foundation to make a political contribution?
The law is clear. Any C3 organization cannot make a political contribution. 527s can be in business, have to be in business totally to make political contributions. C4s, the rule is as long as their primary purpose is social welfare, they can make